Hello everyone, this is Sudhir Kumar Dwivedi, Assistant Professor of Law from GMTech School of Law, Greater Noida. And the topic for today's lecture is privileged communication under the subject Law of Evidence. And this topic has been divided in two parts on the basis of type of privileged communication. Here in this lecture, we will deal with the first part. First of all, it is important to know what is the privileged communication. The privilege of a witness means the right of a witness to withhold evidence to disclose certain matters. There are certain circumstances in which certain persons are not compelled to testify or to give evidence. The right is based on the convenience and public policy. Section 122, Section 132 of the Indian Evidence Act 1872 provide for the privileged communication. So the privileged communication has been provided from Section 122 to 132, and this principle of not compelling a certain person to disclose something before the court or to give evidence is based on the public policy. We will discuss in the later part of the lecture. There are various privileges of witnesses under the Indian Evidence Act, and the person who are covered under this privilege are judges and magistrate, communication during marriage, evidence as to affairs of state, official communication, information regarding commission of an offence, and the professional communication as to the commission of the offence. Under this, they will discuss judges and magistrate, evidence as to affairs of the state, official communication, information regarding any offence, and professional communication and the communication during marriage they will discuss in the second part of the lecture. So first of all, judges and magistrate. Witnesses and documents are the main sources of the evidence. A witness is a person who gives testimony or evidence before any court. As a matter of fact, every person is competent to give evidence, but they cannot be compelled to give evidence. There are certain persons who enjoy certain privilege and they cannot be compelled to testify, that is judges and magistrate, etc. As we know, the Indian Constitution provides protection that no one can be compelled to witness against himself, and here in this privilege, certain other person has been protected to give evidence not only against himself but even against other as well. And the first one is some special privilege is given to judges and magistrate. Section 121 of the Indian Evidence Act provides that no judge or magistrate shall, except upon the special order of some court of which he is subordinate, be compelled to answer any question as to his own conduct in court as such judge or magistrate, or as to anything which came to his knowledge in court as such judge or magistrate, but he may be examined as to other matters which occurred in his presence while he was so acting. So the privilege is regarding the thing that he will not be compelled to answer any question to his conduct, that why he decided to allow the re-examination, why he allowed the witnesses order, how he decided the witnesses order, there cannot be any question regarding that, or he may not be asked to anything which comes to his knowledge while he was acting such judge or magistrate during the proceeding of the case. There may not be any questions. Suppose a matter has been decided by a court of the magistrate of first class, and the matter goes in court of session in appeal. Then the magistrate of first class cannot be asked how he reached on that judgment, what he supposed, how he concluded the things, how he decided the order of the witnesses and all things. Question cannot be asked. He cannot be asked as a, cannot be called as a witness. But if something is happening in his presence, then obviously he may be called as a uh, to explain the thing. Suppose proceeding is going on in a court and someone attacks, even suppose someone attacks to any person within the court premises. It happens in some times, and if someone attacks on the upon some person, and the matter goes before the court in another court, then that magistrate who was sitting as a presiding judge in that court may be examined in that regard, because he will be as a witness in there. But the privilege is regarding what he has considered, or what he has get from the proceeding on in any particular case. He will not be asked a question how he come to the conclusion, what he perceived from the pleadings. He will not be how he presumed the things from the statement of the witness. He will not be asked any question regarding that. But if some event, some incident happened in his presence, then obviously he may be examined in on that regard. Let's see some examples. Suppose A, on his trial before the court of session, says that a deposition was improperly taken by B, the magistrate. B cannot be compelled to answer the question as to this except upon the special order of the superior court. As I said, that it is the duty of the it is the discretion of the court to decide the order of the witnesses. And suppose before the court of session someone is making an allegation against the magistrate that he has uh, improperly taken his statement. So generally the question will not be asked about that unless and until some special order has come from a superior court. And the second illustration is that A is accused before the court of session of having given false evidence before B, a magistrate. B cannot be asked what is said except upon the special order of the superior court. So in the same way, someone is accused before the court of session, is accused before the court of session of having given, and he is accused before the court of session regarding that he has given the false evidence in so and so court before a magistrate, here B, in B, in court of magistrate B, he has given the false evidence. But B cannot be asked what what A said except upon the special order of the superior court, because that is a regard of matter. It is personally, it is not the magistrate is not a witness to be examined what he perceived during the while he was doing trial of any case. So then A is accused before the court of session of attempting to murder a police officer while on his trial before B, a session judge. B may be examined as to what occurred. So we have discussed this point, that if some incident take place before the court of magistrate or during while the trial was going on that point the magistrate may be examined at what occurred in his court or her court. Now the next is evidence as to affairs of state. Section 123 of the Indian Evidence Act says that no one shall be permitted to give any evidence derived from unpublished official records or relating to any affairs of the state except with the permission of the officer or at the head of the department concerned, who shall give or withhold such permission as he thinks fit. So no one shall be permitted to give any evidence derived from unpublished official record. Suppose a judgment has been written by a magistrate, or something has been, or you can say, uh, a new act has been drafted by the member of legislative assembly or the committee, and that is not yet published obviously. So no one can be compelled, the person cannot be compelled to disclose the thing, to give evidence that what the committee has prepared a report, unless and until the concerned department or the head of the department has given the permission for the same, because that is still in the domain of unpublished document, domain of the office. What is to be published, what is not to be published, it will be decided by the department, and the court cannot ask, and generally, that what the committee has made or what laws to is going to be prepared, kindly present before us. They cannot ask. Once it is published, then obviously the court may go behind the fact that how it comes, how the committee come to that report. Unless and until that is not prepared, that is not published, court can't go behind that. So generally, official matter which is related with the state affairs of the state, that should not be, court should not ask to those statement, because they are covered under the section 123 as a privileged communication, or you can say as a privileged statement record. In Duncan versus Camel Larrett and Company Limited, it was held, in case such a situation arises, the court is bound to accept the decision of the public officer without any question. Further, the decision ruling out of such documents is entirely the decision of the judge. It is the court who is in charge of trial and not the executive. The phrase affairs of state has not been per se described in this section or any other provision of the act, so it is not very practical for the judiciary to come up with a single definition of the phrase. Therefore, the court must determine whether any document fall under this category, depending upon the facts and circumstances of every case. However, it is clear that only the court has the power to decide whether any document can be classified as an unpublished document of the state affairs or not. So here the issue was regarding what document will be considered as an unpublished document. So basically it was held that it is in the domain of the executive body, but if there is some, you can say, doubt, then ultimately the court has the power to decide whether any document can be classified as a unpublished document of the state affairs or not. The next is official communication. According to section 124 of the said act, that is the Evidence Act, no public officer shall be compelled to disclose communication made to him in official confidence when he considers that the public interest would suffer by the disclosure. So if something has been received by any public official, suppose a district magistrate has received some information regarding a conspiracy against the government in a particular district or against any particular institution, then the district magistrate is not bound to disclose the thing, uh, because whatever he had what was the communication, because that is protected as official communication under section 124 of the Indian Evidence Act. While section 123 talks about the unpublished document related to the affairs of the state, section 124 restrains the disclosure of all communication made in the official capacity, be it in writing or not, and it is immaterial whether they relate to state affairs or not. In the case of Inri Mantu Bhai Mehta, it was held that it is upon the court to determine whether the document is communication made to a public official in official confidence, and if the document does not deal with any affairs of the state, it may be taken up as a evidence. Obviously, if the matter is not related with the state affairs, then the document is not protected under this section. Now, information as to the commission of the offence. Section 125 of the Indian Evidence Act says that no magistrate or police officer shall be compelled to say whence he got any information as to the commission of any offence, and no revenue officer shall be compelled to say whence he got any information as to the commission of any offence against the public revenue. Explanation attached. Revenue officer in this section means an officer employed in or about the business of any branch of the public revenue. It can be understood by examples. Suppose Harry is a police officer. Someone told Harry about riots that are being planned to happen later today. Harry cannot be compelled to tell where he received such information because this section gives protection. And suppose Ron is a revenue officer. Someone told him that Draco is hiding millions of rupees in black money in his basement. Ron cannot be compelled to tell as to where he received such information. This provision has been made to protect the informant. Otherwise, no one will be dare to inform anything to the public officer. That's why such section has been provided. Even the police officer will not be able to investigate properly. You must have heard about the Mughbir and all the concept. Even in it was in the Mughal period as well, and now it is that there are some Mughbir in every area, and the police get information about the offences from those Mughbirs. So this cannot be ruled out that police officer has to disclose from where they received the information. That's all about the privileged communication. Thank you.